Christopher Fields began dating his wife, R.F., in 2009. They became pregnant in 2010 and married in 2013. After the birth of their daughter, R.F. reports Field began sexually assaulting her while she slept. She testified she woke many times to his fingers inside her. She also testified she would wake with semen inside her when there had not been any consensual touching. In 2016, R.F. woke to find Fields having sexual intercourse with her. She pushed him off and yelled at him about the assault. They started attending marriage counseling in an attempt to work on their relationship and set boundaries. However, she continued to wake to him inside her and subsequently reported the assaults in May of 2017. At a jury trial, Fields was convicted on both counts of second-degree rape and sentenced to 10 years to life for each count. He is now appealing his conviction, arguing the therapist's testimony should not have been admitted due to privilege. At trial, his lawyer agreed it was not privileged, which is why he is also arguing ineffective counsel. Let's take a look.
Thank you, Judge Coburn. May I reserve 3 minutes for rebuttal? Good morning to the court. I'm Oliver Davis. I represent Christopher Fields, and we're asking that this court reverse his convictions below for a series of reasons, the most significant of which involve the violation of the Privacy Act and the question of the marriage counselor privilege. And I can sum up those issues relatively quickly. The Privacy Act is violated by admission of a recording when one party states they do not consent to the recording, because consent is the touchstone of the statute. The presumption of consent that may exist when a party continues to talk while knowing that they're being recorded is no more than just that, a presumption. It is certainly defeated by the language of the statute that says a privilege or that the consent is required. The marriage counselor privilege is not eviscerated by the traditional third-party rule when that third person is the other spouse in the marriage. And that also comes from the plain language of that particular statute. The touchstone of the Privacy Act is consent. This recording, recorded by the spouse, the complainant, did not include an announcement that the conversation was being recorded. That announcement must be made, and it must also be recorded.
Do you think that the announcement has to be verbal?
Yes, by the plain language of the statute, an announcement would have to be verbal. Perhaps it could be in writing. It's certainly not an announcement to place a recording device.
Well, let's say a situation which I don't see the facts in this case, but where somebody held up a phone, showed it to them that they were recording, indicated that they're recording, and the record suggested that they know that they've showed them they're recording. And is that going to be something that would satisfy the announcement or recording?
I think it might pose an interesting question in the area of the announcement rule, but it certainly would not trump a circumstance in which another party affirmatively objects to the recording, whatever way it may have been announced.
Now, I know that in this case, there was an evidentiary hearing so the state could introduce the circumstances by which that recording took place. So they had an opportunity to ask RF, in fact, what took place regarding that recording. And correct me if I'm wrong, but I didn't see anything regarding any question about how she started the recording, whether she showed that she was starting the recording or anything like that to Fields.
There was a discussion about was the cell phone, which was the recording device, was present on the table in between the two individuals that were talking. The importance of the first part of the recording, as your honor has mentioned, is that there was not the required announcement that this conversation is going to be recorded.
I have some questions regarding the second issue regarding privilege. It looks like in the record, there was this big debate over the summary that the counselor had put together based on her notes, and that physical piece of paper of the summary was what the defense counsel believed was in what he called the public sphere. Is that an accurate reading of the record?
I think it's an accurate reading of the record, but it's the Privacy Act. The counsel was incorrect in assuming that the privilege statute did not apply based upon the traditional third-party rule. The presence of a third party, which traditionally eviscerates privilege between provider and patient, does not apply to a marriage counselor simply because the other spouse is attending.
I know that the state had argued below that, in fact, there was a waiver of that privilege if it exists, based on what they're arguing that Mr. Field has subpoenaed this and had used this in the civil family law case. I know there was argument as to that, but was there any evidence in the record to support that that actually happened?
I don't know that there was evidence in the record that it was subpoenaed, but even if it had been subpoenaed for purposes of discovery, that does not eviscerate the privilege itself. As a party, he's entitled to know what the other party is attempting to get admitted. That was not a waiver of his right to object to admission of any testimony, oral, written, via a report, etc., by Ms. Stenger, the marriage counselor. I do want to emphasize that all with regard to the Privacy Act, the courts have all said that the standard of review is de novo. So this court should not feel that it needs to defer to any decision made by the court below in any aspect of the Privacy Act question. I think in particular, it's important to note that if one were able to say they're recording something, a private conversation, and undeniably one of the factors for whether a conversation is private is the nature of the conversation. A conversation between two spouses about troubles in their marriage is absolutely a private conversation. But that private conversation cannot, the protections of that private conversation cannot be eviscerated by the very fact the other party announces that they're recording the conversation, because it would render the act meaningless.
And that's the crux of the argument from the state, as I understand it, right? That there is some sort of, they have to, but they at least implicitly acknowledge that there was an objection to consent, right? We do not consent. So their argument essentially is that he knew he was being recorded even after he objected, and he continued to talk. So there's some kind of waiver essentially of the idea of the privacy issue generally. And there's some implication that he could have just stopped talking, right? He knew he was being recorded, just stop talking if you think this is something you don't want out there.
Right.
Did you want to respond to that?
Well,
because you're saying that you can't eviscerate that right by waiver of some kind.
Yeah, the rule that a waiver exists when you know the matter is being recorded comes from Modica primarily, and it has to do with prison telephone calls, which are made below a giant sign that says, this is going to be recorded. And there are other warnings in the electronic message. It's not a waiver to keep talking when you're repeatedly saying you do not consent to the recording, and when you learn from the spouse who's making the recording that this is not blackmail that she's going to dispense to others, as she stated to her husband. Thank you, Your Honors.
Good morning, Your Honors, and may it please the court. I'm Gabriel Jacobs on behalf of the state. The defense, I'd like to start with the Privacy Act issue. The defense talks a lot about consent, but there's two elements to the Privacy Act, and consent is one and privacy is the other. And if this were, say, a sufficiency of the evidence argument and a crime involving two elements, and I was talking about element A and the sufficiency argument was about element B, it wouldn't do me a lot of good for me to keep talking about how much evidence there was supporting element A. And here, there's really no dispute about the consent element of the Privacy Act. It's very clear and indisputable from the record that Mr. Fields did not consent to the recording, but it's not so much about the issue of waiver. It's about the applicability of the act, and the Privacy Act does not apply to conversations that aren't private. And
what are you relying on to suggest that this conversation was not private?
So whether a conversation is private is something that's, there's no bright line rule. It's just something that's taken from the totality of the circumstances. Certainly, as counsel discussed in the jail call context, there's case law suggesting that when you're being recorded, that's certainly something. It's not completely dispositive, but it's certainly something that weighs heavily against the idea that it's meant to be a private conversation. And I believe it was Modica, I want to say, that said, this isn't a bright line rule where every conversation is always going to necessarily, as a matter of.
You can see there was no announcement that there was going to be recording at the beginning of the recording, which is what the statute requires.
For a non-private, exactly, but
Right?
that's a different element.
So then we look at KIP and the factors that we look at to determine whether it was a private conversation.
So I think with the recording announcement is different than whether that doesn't go to whether it's private. That's something that can sort of immunize a conversation under the statute. That sort of presents.
What is it factually that you think indicates this conversation that took place in the home between a married couple about very intimate details was not private?
Well, first of all, both parties understood that it was being recorded. B,
Where's the evidence that Mr. Fields understood it was actually being recorded versus it could be recorded?
Because he kept saying, "Stop recording me."
Why is that not he said, "You don't have permission to record me," correct?
And I believe at one point he said, "This feels like surveillance. This feels like you're collecting evidence. This feels like."
And why couldn't that be because of the nature of their relationship and the dispute that in fact he was afraid that she would record it? But how does that show that she knew for a fact that she actually was recording? I mean, couldn't that have been asked at the evidentiary hearing? The whole purpose of the evidentiary hearing was to establish this?
Well, certainly he understood that at least there was, if nothing else, if someone picks up the phone in the jail and there's a recording that says, this call is subject to monitoring, they're not sitting in the surveillance office at the jail. They don't see it recording. They're assuming that it's recording based on the evidence that's before them on the totality of the
distinguishable. They're
circumstances.
actually being told your calls, will be recorded. Isn't that different from this?
I don't think so, because in this case, Mr. Fields is saying, "You don't have my permission to record. I don't want you recording me. I think you're treating me like evidence. This is blackmail." And then he says, "I can give you what you want if you stop recording so we can have a real conversation." So clearly he understands that he's being recorded. And also this is a hostile conversation. He understands that the victim in the record talks about how she had previously had conversations with Mr. Fields, how "I'm going to record you so people don't think I'm crazy." She essentially tells him that I'm building a
The
record.
testimony at the evidentiary hearing, it talks about how she alerted of recording Mr. Fields based on what she said in a counseling session, not anything that she said during that conversation.
It's not about, whether she made an announcement, it goes to that separate subsection of the statute, but that doesn't control whether or not it's a private conversation. What controls whether it's a private conversation is the totality of the circumstances and the facts before the court. And
Why can't he trust that if she has a phone in her hand saying, "You don't have permission, I don't consent to recording," that she would respect that versus assuming that she's recording him secretly?
Well, I think this is clearly a relationship where trust is absent. They're talking about, she's accusing him of raping her. And also, they discuss getting divorced in the same conversation. This isn't a harmonious.
Very intimate conversations between a couple.
A conversation.
I feel like we're mixing and matching adjectives here. And one of them is that somehow a hostile conversation, stipulate it's a hostile conversation, it can no longer be a private conversation. Right. But and just to take two extremes, if they had that same conversation in a coffee shop, right, then that'd be one thing and your argument would be much stronger. But if they're having this in their room alone with nobody else present about a subject matter, which is as intimate as one can get with your significant other. So that's, again, if you want to focus on privacy, I get that there's a distinction between privacy and consent, but if you want to focus on privacy, we need the facts laid out in KIP subject matter, duration, location, relationship of the parties to bolster your argument, not just hostility.
So hostility, and so just to be clear, the state's argument is not that, a hostile conversation necessarily is not a private conversation. That's just one part of the universe of facts in this case. But the important fact in Kip was that in Kip, it was a secret recording. The defendant in Kip didn't know he was being recorded. It was being done surreptitiously.
You stated earlier that he said, well, stop recording me. But when I look at the record of what he said, he didn't say stop recording me. So I don't know where you're getting that. I hear him saying, I don't want, right? What I don't want is to be surveyed, right? Recording people is not acceptable. I don't see where he actually says, stop recording me.
So I don't have the exact RP, but and I could present it to the court afterwards, but he says something to the effect of, and this may not be verbatim, I want to give you what you want, i.e. an apology, but I can't do it. Stop recording so we can have a real conversation. I believe that's reasonably close to a quote, but I can't certainly stand up here and say it's verbatim. And but it's one of those phone calls where he says, I want to give you what you want, but I can't, because you're recording. Words to something very strongly to that effect, if not, not verbatim. But, again, if you're having this private conversation, in an area where that it's being recorded by someone who is essentially, you believe, collecting evidence against you.
So you would concede that this totally turns on whether he knew that he was being recorded.
I think that is probably it doesn't turn completely on that as a matter of law. But I would say that is the most significant fact in this particular case. Modica was pretty clear that every case has to be taken on its own facts, and the bare fact of recording alone does not, as a matter of law, defeat the Privacy Act. But it is a very significant fact, and it's, I think, the most significant fact in this case.
I don't want you to lose time before we go on to the second issue. So let's get there. Regarding the privilege.
I'll just assume I have your vote on this, Your Honor.
I would never assume anything. On the privilege, I see that the prosecutor argued down below, he waived, this is why he waived, but I don't see anything in the record that supported that argument.
So there's again, the actual form, there's indications in the record that in the civil case, again, there was some waiver of privilege that Mr. Fields actually signed. But I think it's important to look at the procedural posture of this argument. This is not actually challenging the waiver itself. This is ineffective assistance of counsel. So it's not necessarily, is there evidence of the waiver?
I understand that. I understand the procedure of how it's coming before us. So nevertheless, in order to determine whether he was deficient, we have to determine, in fact.
Again, well, that's true, but because it's coming as ineffective assistance, counsel is presumed effective. So it's the defense burden to overcome that presumption of effectiveness. So essentially, the defense has to show that defense counsel was wrong about there being a signed waiver, or that he was somehow unreasonable to believe there was a signed waiver.
Right, and if defense counsel is at a hearing where a prosecutor is making an argument but has no evidence to support that, with the defense counsel, shouldn't they argue that there's nothing to establish that in fact it's been waived?
I mean, if he knows for a fact that it exists and that it's easy to produce, he might very well not do that. I mean, if it's undisputed between the parties that this document exists, why would rational counsel bother to raise a big fuss about it if it's not a disputed fact? If both parties are under the understanding that this document's there and exists.
But defense counsel actually said my client has not waived in that hearing.
He said that if one party wants it in, it comes in, which is true if there's a waiver. If the privilege,
which is different than saying my client has not waived.
And in that case, then it fails on the harmless prong instead of the deficiency prong. But either way, the ineffectiveness claim fails. It just depends on, did he, in that case, what the resolution would be? Well, he made the wrong objection, but the document was admissible anyway, or there was another reasonable argument. It doesn't matter which prong of ineffective assistance the Strickland test fails. But when there's a written waiver, and I also would disagree that a third party, the RF could testify to what happened in that hearing. She's not bound by any privilege. And since, so what's the policy value in preventing Ms. Stanger from testifying if the information is already out there at this point? And I
respond to your thing about the policy value, but you've run out of time, so we'll move on.
I'll just have to imagine the response, Your Honor. Thank you. I'd ask the court to affirm Mr. Fields' conviction.
The KIP factors obviously lead one to the conclusion that this was the most private of conversations in terms of subject, location, et cetera. in that circumstance, the protections of the Privacy Act can't be eviscerated because a party holds up a phone that shows she's recording and the other person.
I'm going to stop you for a
repeatedly
second there.
objects.
Where in the record, well, obviously the record is plentiful that she had a phone because she testifies she always has her phone in her hand. But where does it show that it showed that it was recording?
I would certainly defer to your assessment of the record that that was not stated, but below it does appear that he knew it was being recorded, but we still prevail. If you can record a private conversation over the affirmative objection of the other person, then the Privacy Act.
What makes you think the record suggests that he knew it was being recorded?
Well, he said things like, I want to talk. She wanted him to acknowledge to her.
Is there a distinction between knowing it could be recorded versus knowing that actually was being recorded?
I don't think I'm conceding anything important by stating that he knew the conversation was being recorded by the phone, but he's repeatedly stating that he doesn't consent, and it would be an extraordinary circumstance and circumvention of the plain language in the core of the Privacy Act if you could record a private conversation and then have that recording admitted in court over the repeated emphatic objection in the recording of the other party. And the other party, the defendant here, also was told by his wife who was recording, this is not going to be used for blackmail. It's not going to be dispensed.
Can I ask one last question? Just
yes.
Real quick. So the state clarified that it's not a waiver argument per se, but and he acknowledged by still talking that it was no longer a private conversation. I mean, the way I read it, he said, you're going to use this for some reason. You're going to use it to blackmail me. So in other words, it's going to be public. She said, no, I'm not going to use it to blackmail. And then the state saying, well, he still must have understood in some level that it's going to be used publicly. So it's not a private conversation. My question to you, though, is what was his option? I mean, he wanted to have a conversation with his wife about something extremely significant at that moment. What was his only other option, to rip the phone away from her?
His option was to do what he did, which is to tell her to stop recording so that they could have an unrecorded private conversation. But his concerns about it being dispensed and used as blackmail were specifically rejected by his spouse, who said, that's not what I'm using this recording for. Does that answer your Honor's question? Again, I just don't think that if repeated objections to the recording could make a conversation non-private, the Privacy Act is rendered meaningless.
Thank you, Your Honor.
Thank you very much.
Following these arguments, the court reversed the conviction and remanded for a new trial. The court stated the trial court had erred in admitting the recording of the conversation between Fields and RF in violation of the Washington Privacy Act. Defense counsel was ineffective for conceding that the privileged testimony was admissible. Did the court correctly apply the Privacy Act here? Let me know what you think in the comments below. And if you like this video, please consider subscribing for more court arguments every week. Until next time.